Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll explore 3 scenarios involving derivative claims, a key topic in business law under FLK1. Let's dive in. A private limited company has 2 shareholders. The minority shareholder owns 30% of the shares, while the other owns 70% and is also the sole director. A customer owes the company €50,000 but refuses to pay. After obtaining legal advice from his friend who is a conveyancing lawyer, the director decides not to pursue the debt due to the complexity of taking legal action. As a result, the company declares lower than expected dividends. The minority shareholder now wishes to bring legal action against the company, the director, and the customer in response to the unpaid debt and reduced dividends. What is the most appropriate course of action available to the minority shareholder? A. The minority shareholder may sue the director or the customer. B. The minority shareholder cannot sue the director or the customer. C. The minority shareholder may apply to the court for permission to bring a derivative claim on behalf of the company against the director, but not the customer. D. The minority shareholder may apply to the court for permission to bring a derivative action against the company. E. The minority shareholder can sue the customer directly. The best answer is C. The minority shareholder may apply to the court for permission to bring a derivative claim on behalf of the company against the director, but not the customer. A derivative action is a claim brought by a shareholder on behalf of the company against a director, or another person in control of the company, for a wrong done to the company. The wrong here is the director's decision not to pursue a recoverable debt. This may amount to a breach of duty, e.g., failure to promote the success of the company or act with reasonable care and skill. The customer owes money to the company, not the shareholder. The shareholder has no standing to sue the customer directly. Scenario 2. Same background about the 2 shareholders and that a customer owes the company money. The customer is now in liquidation and administered by liquidators. The company's sole director has been on sick leave for over 6 months and has taken no action to recover the debt. The minority shareholder now wishes to bring legal action against the company, the director, and the customer in response to the unpaid debt. What is the most appropriate course of action available to the minority shareholder? A. The minority shareholder may apply to the court for permission to bring a derivative claim on behalf of the company against the director. B. The minority shareholder may bring a direct claim against the customer in liquidation. C. The minority shareholder may sue the director personally for failing to act. D. The minority shareholder is barred from taking any legal action until the director returns. E. The minority shareholder may bring a derivative claim against the company and the customer. The best answer is A. The minority shareholder may apply to the court for permission to bring a derivative claim on behalf of the company against the director. Since the company, not the shareholder, has suffered the loss, and the director has failed to act in the company's interests, the correct legal response is a derivative claim under Part 11 of the Companies Act 2006. Here, the director's failure to act to recover a significant asset of the company, even while on sick leave, may constitute a breach of duty under Section 172, duty to promote the success of the company, or Section 174, duty to exercise reasonable care, skill, and diligence. Scenario 3. Same background that a customer owing money to the company is in liquidation. Before any recovery action was taken, the sole director passed away, leaving the company without any directors. The minority shareholder now wishes to bring legal action in response to the unpaid debt and is concerned about the company's ability to act. What is the most appropriate step the minority shareholder can take? A. Apply to the court to bring a derivative claim on behalf of the company against the deceased director's estate. B. Apply to court to appoint a new director so the company can recover the debt. C. Bring a direct claim as representative of the company against the customer and liquidators for non-payment. D. Bring a direct claim as representative of the company against the liquidators for non-payment. E. Apply to the court to bring a derivative claim on behalf of the company against the customer. The best answer is B. Apply to court to appoint a new director so the company can recover the debt. Since the sole director has died, the company is now incapable of acting, including pursuing debts or making decisions. The correct first step is to ensure that the company is made operational again by appointing a new director. If the company's articles or shareholders agreement do not provide a mechanism for appointing a new director, then the minority shareholder may apply to court to appoint someone who can manage the company's affairs, relying on the court's inherent jurisdiction or just and equitable grounds. This is necessary to allow the company to act against the customer or the customer's liquidators. A derivative action is not possible here because it must be claimed against living directors or those responsible for wrongdoing. Also, there is no allegation of prior misconduct or breach of duty. This table illustrates when a shareholder may take legal action due to a company's failure to recover a debt. In Scenario 1, the director refuses to pursue a €50,000 debt. This may amount to a breach of duty, allowing the minority shareholder to bring a derivative claim on behalf of the company. The shareholder cannot sue the customer directly, as the debt is owed to the company. In Scenario 2, the director has been on sick leave for 6 months and fails to act. Even without misconduct, prolonged inaction may still breach director's duties. A derivative claim remains the appropriate remedy, as the loss is the company's. In Scenario 3, the director has died, leaving the company without leadership. Since there is no wrongdoing by a living director, a derivative claim is not available. Instead, the shareholder may apply to the court to appoint a new director so the company can recover the debt. Have you noticed how a slight change of fact can affect the legal outcome? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.